Hi, thank you. Yes, my name is Dana Lawrence. I am the Fair Hearing Procedures Manager here at the Regional Center. I also have with me our case management directors, and I'm going to allow them to introduce themselves.
Hi, I'm Gabriella Sharati, Director of Consumer Services.
Good afternoon. I'm Jasmine Zinnerman, another Director of Consumer Services.
Good afternoon. My name is Christina Prus, and I'm the other Director of Consumer Services.
Hey, thank you all. Sandra, will you go to the next slide? Okay, so my department is called Contract Administration. I wanted to introduce briefly the members of my department. They are not here today. They are off doing work, but I wanted to let you know who makes up my department. We are a department of 4 people, and we have about 40 years of regional center experience between all of us. I have 2 people who are called contract officers currently. They handle due process for the agency. I have Stella Dorian. She's been with the Regional Center for over 25 years now. She started off in case management, went to risk assessment, and now is in due process. I have Christina Aguirre, and she is relatively new to the Regional Center, having been here just around 3 years. She was previously in risk assessment and now is in my department. I also have Monica Munguia. She splits her time between the educational advocate position as well as contract officer. She's been with the Regional Center for around 8 years, and she started off in case management as well. Again, I'm Dana Lawrence. I've been with the Regional Center just about 5 years now. Previously, I was a prosecutor in the Atlanta area, and my background includes education. I have degrees in special education, deaf studies, and a law degree. So that's just a bit about me. Let's go to the next slide. So what is due process? I've said that we handle the due process for the agency. Due process exists when dealing with most agencies. Some of you might be familiar with like your local education, your school district, and their due process. But it's generally like a complaint process, or it could involve hearings in front of a judge to fix any sort of disputes that might be happening between you and the agency. Let's go to the next slide. So my department handles all of the due process for the agency. This includes the Lanterman Act fair hearings. So those are hearings for our consumers who are receiving services under the Lanterman Act. Fiscal audit appeals with our vendors, vendor appeals, as well as vendorization appeals. Those appeals are specific to the services that vendors provide and their vendorization with the Regional Center. I'm sorry, I realize that I'm talking very quickly, so I'm going to slow down just a little bit for our interpreter. We also do early start mediations, early start hearings, and Lanterman Act 4731 rights violation complaints. So those are some of the things that our department does. We also have other duties that we tend to. We review all notices of action. Sometimes those will be called notice of proposed action, or NOA, or NOPA. Again, Monica Munguia handles the educational advocacy for us. We do quarterly reports to DDS regarding the number of fair hearings and 4731 violations, complaints that we have. We also provide a lot of documentation to DDS, whether that's in an early start complaint that they are investigating, any 4731 appeals that they might have received. And we also respond to corrective action plans when Regional Center has been found in violation of a consumer's right. We conduct new staff orientation trainings for fair hearings, Lanterman Act, educational advocacy, and on 4731 complaints. And we also provide consultations to case management from time to time. So on to the next slide. So the Lanterman Act was created to protect consumers from treatment those with developmental disabilities have historically endured. The Act recognizes that persons with developmental disabilities are vulnerable to abuse, neglect, and the deprivation of their rights. Of course, our consumers have all the rights that are guaranteed under the Constitution and by the laws of the state of California. but the Lanterman Act establishes additional rights for our consumers. The rights are found in a variety of places within the Act, which there's a link to on our website. And the section numbers that you're going to see are where you can find the language for the specific right within the Act. So I'm going to let's go to the next slide. Oh, no, stay there. Sorry, stay there. So these are some of the general rights that are found, the general rights for our consumers. We're going to go into more specific rights about IPPs, right to adequate notice and things like that shortly. But these are the general rights that our consumers are granted in the Lanterman Act. Our consumers have the right to treatment and rehabilitation, the services that are in their IPPs, the right to dignity and humane care, the right to prompt medical treatment when they're in need, the right to make choices within their own lives, because we're looking to have our consumers have a greater independence in their lives, and the right to an investigation, a prompt investigation if there's suspected abuse. So I'm not going to read off the entire list, but these are all found in Code Section 4502. Let's go to the next one. So these are additional rights that our consumers have. They have the right to be provided information to help them understand how their choices, and generally that information is provided in their IPP meetings or when they ask their consumer service coordinator questions. They have the right to have their choices respected. If they don't want a service, we have to respect that. And they have a right to have information provided in their language of choice. And you'll see that right scattered throughout the Lanterman Act in various places. For our consumers who reside in community care facilities and or who were committed to state hospitals, the Lanterman Act specifically sets forth additional rights geared towards those individuals so that they can wear their own clothes when they're in those facilities. They have the right to have writing materials made available to them if they want to write letters, to receive phone calls, and to have confidentiality when they're conducting those phone calls. So those are rights that are specific to consumers in those facilities. Okay, let's go to the next slide. Now I believe case management is going to present a couple slides.
Yes, hi, thank you, Dana. This is Christina. Good afternoon again. So we also have other sections that we wanted for the individuals to be aware of. When you're looking at section 4640.6, it basically also talks about the rights that we have to assist in making sure that the clients know how to access their benefits, healthcare, special education advocacy, affordable housing. In general, what are some of the resources that are out there that are available for our clients? We also have section 4640.7, which it is the right that our clients have to a designated service coordinator, and also the right if they need assistance in accessing the community. And when we look at section 4643, it talks about our eligibility calendar or eligibility timelines, where we have the right to, the clients have the right to an eligibility determination that is less than 120 days, right to eligibility determination in less than 60 days if waiting causes potential risk in mental or physical development or risk of moving to a more restrictive environment. And also the right to communicate in the native language. You can request if that is for better interpretation and understanding. Within the next section that you see here, which is 4643.5, it is the right to be eligible for services at any regional center within area of residence. As you know, we have 21 regional centers within the state of California. And when family or the client moves to a different catchment area than the one that they have previously been residing, there is a right to a smooth transfer of the services and the client's file to the regional center that is within the new catchment area that the client and the family reside. There is a process, and in our website, we have actually a few weeks ago, we have posted our procedures so that families know that they have a right to request for a transfer when they are moving to a different catchment area, and we will process with the other regional center. There's also the right to have an IPP, an individual program plan meeting, within 30 days once it is received by the new regional center, and especially talking about services and supports that are available within that area. Alternative services in least restrictive setting possible until the new IPP is complete. And then within the sections shown below, 4646, 4646.5, and 4648, it talks about the timelines for the initial IPP, initial individual program plan, that is within 60 days of being found eligible for Lanterman within a regional center. Also, the right to have the individualized individual program plan considering the needs and the preferences of the client. And also the right to be provided with the individual program plan. A copy needs to be provided to our clients. And I believe the next one is Gabby.
If I'm sorry if I can interrupt. The interpreter is asking if we could please slow down a little bit to allow her to interpret that properly. Thank you.
Absolutely.
Okay. Thank you, Christina. I'm going to move on with welfare and institution codes for section 4646, 4646.5, 4647, 4648. And these are the rights that are related to the IPP process. The individual has the right to participate in the IPP process and to ensure that the IPP and provision of the services and supports by the regional center is centered on the individual and the family of the individual's needs and takes into account their preferences, as well as promoting their community integration, independence, productivity, and normal lives and stable and healthy environments. The individual program planning is a collaborative process with the IPP team. And the IPP team is a makeup of the individual that we serve and who they would like to attend in addition to regional center at this meeting. It could be a parent, it could be a friend, it could be a teacher, someone that is helping them through the process of the planning and has valuable information they can share with the team. Decisions concerning the goals and objectives and services and supports will be included in the IPP, and purchased by the regional center or obtained from generic resources shall be made with an agreement, and if appropriate, the individuals participating in the IPP would also be a part of that plan. If a final agreement regarding the services and supports to be provided to the consumer cannot be reached at the initial meeting, we can reconvene within 15 days or as agreed upon if needed sooner or later than those 15 days. If subsequent meetings do not result in an agreement, the disagreement that is being made is referenced on the signature page of the IPP. So at the conclusion of the IPP meeting, the regional center shall provide the consumer in a written or electronic format a list of the agreed upon services and supports, and if known, the projected start date, the frequency, and the duration of services and supports that are being provided. There's a few other areas. For example, if an individual has become eligible with the regional center, they have the right to an initial IPP within 60 days of being made eligible. The individual also has the right to a written format of the IPP. For parties of the IPP team to also get written confirmation of when the meeting is being held and at what time. The request If a different language is needed during that IPP for translation services, the individual has that right to make that request. That would include any language as well as sign language if needed. The individual also has the right to have the need for extraordinary care and services and supports and supervision taken into consideration for consumers who are minors. Okay, next slide, please. In the next area, we're reviewing Welfare and Institution Codes 4646, 4646.5, and 4647, 4648. These are all continued in this area of the documentation of IPP, in which the individual we serve has the right to a copy of the IPP within 45 days in the language of their preference. The right to regular periodic review of that IPP. And so generally, an individual can ask for an IPP at any time. However, we review IPPs on an annual, quarterly, or as needed basis. Generally annually for individuals that are living in the family home, and quarterly for individuals living outside the family home in an independent living environment or at a facility. The individual has the right to review the IPP within 30 days of a request, or 7 days if there's a health and safety, and it is a right for an IPP to be held. So at any time, the individual has the right to request an IPP that needs to be completed within 30 days or 7 days if there's a health and safety need. The right for the service coordinator to be assigned. All cases are assigned to a service coordinator. Right to a written notice of permanent change in service coordinator that needs to be provided within 10 business days of that notification. The right to a new service coordinator if that's a request. Right to services and supports that are included in the IPP. Flexible individualized services and supports that are documented in the IPP. And the right to have a choice of service providers that generally are considered at the inception of the services being implemented. The right, if there's a crisis or emergency service for IPP planning and for service implementation. The right to assisting in accessing generic resources, and to be informed of the fair hearing process. And I will hand it over to Christina.
Yes, so as you saw in the previous slides, there was information with regards to the rights and the timelines. A little bit more with regards to the individual program plan process is that there are timelines, as you saw, to make decisions when there are some requests that are what we would call exceptional requests or exceptional circumstances. So what do we consider when we're making a decision and when we're reviewing? We want to make sure that we are assessing the need, that we're looking at the individual's needs, strengths, what supports, what are, based on our assessment tools, what are the needs that definitely need to be provided or services provided for the individuals. We will look at extension of timelines with regards to if we are looking and identifying and we haven't been able to complete the assessment, we will request from our families to provide us with an extension, to waive an extension for the 15 days to make a decision. We also, sometimes when you hear that there might be a delay, is if certain documentation or certain information that we have requested, it has not been received. So there are different factors, but we try our best into making the decision as soon as possible, especially when we are looking into the health and safety of our clients. What we also have in place is for our purchase of service. If a service is identified through the IPP, the individual program plan, and the agency, the provider that has been chosen for the service has staff available to start as soon as they can, then the service coordinator can create a purchase of service with the start date at any given time throughout the month. It doesn't have to be the 1st, doesn't have to be the 15th of the month. It could be based upon the availability and if there are no other exceptional circumstances that will kind of impede for this to start right away. I believe the next one is Jasmine.
Yes, thank you, Christina. So we're going to discuss the Welfare and Institution Code sections 4687, 4688.05, 4688.21, and 4689. And I think these are not as commonly discussed or as often brought up in topics. And so please know that consumers also have a right to have relationships, to marry, be part of a family, and to be a parent. Rights for adult consumers include having independent living skills services, as well as customized day services to meet their needs. Adult consumers also have the rights to live in their own homes with support that comes through IPP planning process. They have the right to be provided with information regarding supported living. And we have supported living orientations and informational sessions. You can reach out to your service coordinator to get that information. And then they also have a right to have quality of service monitored. And so that's through case management visits, but also through our QA process. And please note that those rights apply to unconserved consumers. Thank you. I'll turn it back over to Dana.
Thank you all. Okay, so what happens if you go through the IPP process and there's a disagreement about the services and supports that are being included in your IPP, or what regional center will agree to do when you want something different? Well, you have a right to something called adequate notice. And the way that we provide adequate notice is through a written document. It's called a notice of proposed action. Sometimes you might also hear this referred to as a NOPA or an NOA. So in this notice of proposed action, there should be information provided to you about why the regional center is denying your request. A statement of basic facts, how the request was made, why the request was made, why you wanted the service or support, the action that the regional center proposes to take. So if we will agree in part or if we're going to deny in whole the request. The effective date of the action. So say that we are saying that we're going to terminate your respite services. We can't terminate them immediately. We have to give you 30 days notice. So the notice of proposed action will give you the date that these services will terminate. We have to provide you with the statute section justifying why we can't continue or why we will not fund for the service that's requested. You will also be provided with information regarding where to file or how to file for a fair hearing, and the notification of your rights to a fair hearing. A notice of proposed action must be sent to you in writing within 5 days of the decision being made. So if you request a service today and regional center requests additional time to make that decision, at the end of that additional time, within 5 days, you need to get the notice of proposed action sent to you. They must be sent via certified mail, which means that you'll have to sign for the notice of action. And you will have the right to file for a fair hearing, which within 30 days of receiving that notice of action. Now, some of the fair hearing language and the processes are about to undergo a drastic change as a result of trailer bill language that was just passed. Most of these changes will take effect in March of next year. So you'll be hearing a lot about that, I'm sure. So what happens if you don't get a notice of action? You still have the right to file for a fair hearing. And I'm going to, in the next slide, go through the fair hearing form and where you can find it. So this is the copy of the fair hearing request form. It's found on our website. It's found on the DDS website. And also it can be provided to you from your case manager. What's important about this form is that all the applicable information needs to be filled out before it will be accepted by the Office of Administrative Hearings, who provide us with the judges who will hear our dispute. What I'd really like to point out is the section that says requester's name if not claimant. So say you're a consumer, an adult consumer who's not conserved, but you want somebody else to represent you at the hearing. You would need to fill out this part of the form and sign this part of the form. You'll need to provide us with the name of the person who you want to represent you, and you will have to sign it. The Office of Administrative Hearings will not accept the form from an adult consumer without that being signed. Also, if you're a parent of a child consumer and you don't want to represent your child at the hearing, but you want somebody else to represent them, maybe you found an advocate or a friend who's knowledgeable about this area, and you want them to represent you. You, as the parent of that child, would fill out this requester's name if not claimant, and then you would also fill out the representative authorization part. I'm sorry, this applies, the representative authorization portion is what needs to be filled out, designating who will be representing the consumer and the signature of either the consumer or the parent of the consumer. Let's go on to the next slide. So this is the second page of that document, and this document will be provided to you when you get that notice of action. Again, if you do not get a notice of action, then you can always find this document on our website and on the DDS website. So it lists the appeal rights, and we're going to go into them a little bit more in just a few slides, but it does show you the rights that you have throughout the fair hearing process. The next slide, please. This is the fair hearing request form in Spanish. It also is available on our website and on the DDS website. If you need it to be filled out in another language, your consumer services coordinator can assist with that. And if they have any questions, they can always reach my department for assistance. Let's go to the next page. These are the rights during fair hearing in Spanish. Okay. So what rights do you have during the fair hearing? Again, some of these are going to change in March. So you have a right to be present at the fair hearing. Currently our hearings are being held via Zoom. So it is a virtual fair hearing. You can appear on screen, you can appear via telephone, however you are most comfortable with. You have a right to present evidence, written and oral, which means that you have a right to bring witnesses to the hearing who can testify on your behalf. If Regional Center has witnesses, you have the right to cross-examine those witnesses, which means that you have a right to ask them questions. Again, if you don't want to represent the consumer or the consumer doesn't want to represent themselves, you have a right to designate a representative for that hearing. Say you file for a fair hearing and you realize that you need information that is contained in the consumer's chart. If you make the request for that information, when you're in fair hearing, Regional Center must provide you that information within 3 days. During the hearing, you have the right to have an interpreter in your language of choice. And this next one is something that we called aid paid pending. So say that you're going to hearing because Regional Center is going to terminate your respite and you're already getting respite. So if you file for a hearing within 10 days of receiving the notice of action, Regional Center must continue those respite services at the current level until the end of the hearing and the judge makes the determination. That's called aid paid pending. You have a right to request an informal meeting. And if you request an informal meeting, that will happen with a member of my department. and it must be done within 10 days of you filing for that fair hearing. Following that informal meeting, within 5 days, you must receive a letter summarizing what we discussed during that informal meeting and a review of the information that's available in the consumer's chart that's relevant. We must also tell you whether Regional Center has reconsidered our decision to deny the service or support as requested and why. For Lanterman fair hearings, again, these are fair hearings for people who are receiving services under the Lanterman Act. Does not apply to our early start consumers unless they're receiving services under the Lanterman Act. You have the right to request a continuance. Now, you can we have a lot of continuances being requested currently because people might have COVID, and the Office of Administrative Hearings will allow for those types of continuances. If you're not available on the date that the hearing is set for, you can request a continuance and it would pretty much be granted. You have the right to have your issue heard by a judge within 50 days of you filing the fair hearing request. If you request a continuance, though, the hearing might be set outside of that 50 days and you have to sign a time waiver in order for that continuance to be granted. And once we have gone to hearing and everybody's presented their witnesses and their evidence, the judge has to decide whether you win or get the services and supports that you requested, or whether Regional Center was correct in denying that. And you are supposed to get that decision within 10 days of the completion of the hearing. Let's go on to the next. So we've talked a lot about the rights, and case management did a fantastic job of going through the rights in the IPP process. What happens when you think one of these rights has been violated? The Lanterman Act provides under Section 4731 the right to file a complaint, and these are rights violation complaints. Second, please. No, just go back to that one. I'm sorry. I was just catching myself up with my notes. So when you feel that a right has been violated, you have the right to file a complaint. And the complaint forms, which I'll show you momentarily, are available on our website. They're also available on the DDS website and can be provided to you via case management. Once you file your complaint, you have a right to a written response within 20 working days. If we find that a violation has occurred, we will propose a resolution. Most of the time, these resolutions involve more training for whatever staff committed the violation. The rights violations are not set up for there to be monetary compensation or compensatory services if a violation has been found. Once you receive our response, if you don't agree with it, you have the right to have the Department of Developmental Services review our response. You must file that request within 15 days, and our letter will contain the information of how you are to appeal our response. It gives you the website, it gives you the name of the department that you need to contact, and I believe it also gives you their email address. Once the Department of Developmental Services receives your appeal, they do another review of all of the information that was provided. You can provide them additional information and they will request all of the information that Regional Center reviewed in making the decision. Within 45 days of you filing for that appeal, the Department of Developmental Services must inform you whether they agree with the Regional Center's findings or they disagree with the Regional Center's findings. And you should be hearing about the right to file for a 4731 rights violation complaint at the time that a consumer is made eligible and at each scheduled IPP planning meeting. You're supposed to be informed of the right to file a 4731 complaint. Okay, let's go on to the next. This is the 4731 form that can be found on our website and on DDS's website. It's a pretty basic form. It does not provide a lot of space for you to provide the information about the complaint. So feel free, if you are filing for 4731, to attach additional pages with additional information if necessary. If you are the parent of an adult consumer who is not conserved and you want to file a complaint on their behalf, we will address the response to that consumer, and they will decide whether they want to share the results, the response with you, unless we get the authority from them or consent from them to provide the response to you directly. Okay, let's go to the next page. This is the form in Spanish, also found on our website and on DDS's website. Okay. So again, the statute provides the Regional Center with 20 working days in which to respond to a 4731 complaint in writing. During those 20 days, Regional Center is going to do several things. And this is the process that we follow. Once we receive the complaint, we send an acknowledgement of the complaint, and we begin scheduling meetings for everybody that might be involved. That might be Regional Center personnel. It could be people that work for a vendor. It could be the vendor themselves, the owner of the agency. It could be you or the consumer. So we set those interviews and we conduct those interviews, and then we begin gathering all of the relevant information. We might ask you for emails that have gone back and forth, any sort of documentation you have that's relevant to the complaint. After we review all of that, then we have to start researching the law. And we basically go through all of the rights that have been discussed already today to determine if any of them have been violated. We draft our response, and I review all of the responses before they are sent to you. If the response needs to be translated, we have to send it out to one of our vendors to be translated, because you do have the right to receive the response in the language of your choice. And then we distribute the response to you. So that's the process that we follow. And again, all of this has to be done within 20 working days so that we can get the response out to you in a timely manner. Okay, let's go to the next slide. So here's some sources of information that we may review as part of our investigation. We always review the Title 19 notes. Sometimes those are referred to as ID notes. We review all of the IPP documents that are relevant. Any emails, vendor reports, assessment, time logs, behavioral reports. We can ask for whether billing has been done through our accounting department and get that information to review. We'll also look at any APS or CPS reports, Adult Protective Services or Child Protective Services reports. If an IPP meeting that was held had been recorded and information that's relevant might have been discussed during that IPP meeting, we will review the record and listen to the IPP meeting to gather important information. So there's a variety of sources that we look at for information to determine if a violation has been committed or not. And we ask that you provide whatever information you can to us for that review. Okay, let's go to the next slide. So I've mentioned several times that the forms can be found on our website and on the website of the Department of Developmental Services. This picture here, it shows that where you should navigate to in order to find the complaint form as well as the fair hearing form. So you'll go to our website and you'll scroll over to where it says Consumers and Families. You'll press on that, and then the complaint process, you'll press on that, and it'll bring you to the page that will contain all of the relevant information. It explains the different processes of due process, and you can find all of the forms in English and Spanish following that link. Right, that is the end of my presentation and that of case management. So I think it's time for questions.
Thank you, Dana. We'd like to welcome everybody to ask questions. You feel free to raise your hand. You can raise your hand by clicking on the icon at the bottom of your screen that says raise hand, or and we can allow your microphone to be activated. If you have any questions, please feel free to do so. Now is your time. Thank you. It doesn't look like we have any questions on the chat either. Just kind of gone through it. I don't see anything there. All right, it looks like someone's got a question. I see Anna. Anna has raised her hand. One moment.
Okay. Tengo una familia en español, so lo tengo que hacer en español.
Un momentito, señora. For those of you who don't understand Spanish, you guys can also access interpretation by by clicking on the globe icon at the bottom of your screen and going into the Spanish channel, so you guys can listen to the interpretation in English. Okay. Okay.
Gracias, es que tengo la familia que solamente es en español, so le agradezco. La pregunta es cuando la coordinadora nomás simplemente les dice a las familias que no, es algo que puede hacer, no necesariamente les da una carta o diciéndole por qué o qué son las razones por qué no se pudieron cumplir lo que pidió la familia. So, ¿qué es el recurso que la familia tiene cuando no tiene esa carta o esa forma? Porque solamente fue la coordinadora que les dice que no se puede hacer este servicio.
All right. Thank you for the question. If you do not receive a notice of proposed action, you can go directly to our website and download the form for a fair hearing. And you can fill that out without the notice of proposed action. And we will file it with the Office of Administrative Hearings, just as if you had received one.
Okay. Looks like we also have Michelle raised her hand. Michelle Baker. We're going to allow her. Michelle, go ahead and unmute yourself.
Hello. I'm just wondering, when you have your IPP and you request that a goal be added to it, how long does it take? What is the timeline within which we should have that meeting or have that goal officially added? It hasn't been denied, it just hasn't been added.
Thank you for the question, Michelle. I'm going to defer to one of our directors to respond to the timeline on IPP planning.
Hi, Michelle. If you're requesting a IPP, that IPP needs to be held within 30 days, unless it's a health and safety, which should be done within 7 days. Subsequent to that meeting, once it's agreed to, you should be receiving that actual report with that goal in it and services and supports that were agreed to within the 45 days for the actual documentation. But I'm not clear if your meeting was held.
It was not held.
Okay.
So that's why, I mean, we're still moving forward on the goal, but it's not an actual goal listed on the IPP. So I just want to be sure that everything's done appropriately, since I'm working hard to represent the needs of my young person.
Sure. I would just touch base with the service coordinator to make sure that they are aware that that goal is lacking in the final document that you received. And
So I have done that. Do I need to then ask for a supervisor?
Sure, you can ask for a supervisor.
Okay.
And request that we reconvene with you to ensure that we have that planning completed and that it gets memorialized.
Okay. All right. I guess that's probably my next best option then. Thank you.
Thank you.
Thanks, Gabby. Michelle, I also wanted to know, Dr. Weller put in our chat, we do have a document on our website of who to contact if you're having barriers with reaching your CSD. And then they put the link to the document in the chat.
It doesn't look like we have anyone else raising their hand or questions. If anybody has a question, please feel free to do so right now. If I can take a moment to remind everybody that we do have a survey at the end of the town hall. We would very much appreciate you taking a couple of minutes of your time to fill it up. Thank you. Dana, I don't see anything else.
Okay.
Thank you, everybody, for attending. Have a great afternoon, everyone.
Thank you.
Bye.
Bye.